I, Shashank Mishra, as the host, will be having conversation with renowned senior advocate of the Supreme Court of India, Subodh Markandeya. In this video, sir will discuss the query that arose in episode number 2 on Hijab Imbroglio, which so far had more than 100 views. Many of them curious to know about Shariyat Courts, to which you made as a reference toward the end of episode number 2. Please tell us all about the Shariyat Courts under the Constitution of the Islamic Republic of Pakistan.
Good morning, Shashank. Uh, there were too many queries about the this court, this federal Shariat court. So I thought I would better put a video on it before starting anything else. So so far, Pakistan had three constitutions, but we are concerned only with the third one, presently in force since 14th of August 1973. This constitution was framed uh, during the time when Zulfikar Ali Bhutto was the president of Pakistan after the liberation of Bangladesh. So, let us see now what are the provisions for the amendment to the constitution. Articles 238 and 239 of the Islamic Republic of Constitution uh, of the Constitution of Islamic Republic of Pakistan provide for the amendment to the Constitution. Broadly, bill to amend the Constitution can be moved in either House of Parliament, which is called Majlis-e-Shura. Each house has to pass such bill with two-third majority of its total strength before being presented to the President for assent. On such assent, the amendment comes into force. Why I am saying all this is that that chapter 3A of part 7 of this constitution has been added not by any process of amendment of the constitution. It has been added by uh, the military dictator General Muhammad Ziaul Haq, who seized power in a military coup d'etat. He also arrested and tried and hanged Mr. Zulfikar Ali Bhutto. Zia inserted Part 3A of Chapter 7, which deals with the Shariyat courts, through what is called PO 1 of 1980. Now, PO 1, I don't know what's the constitutional status of PO 1 of 1980, but obviously the president, even if he was the president, he had no power to add, amend, or delete anything from the constitution. There is a legislative process for that, which I have pointed out, that is Articles 238 and 239. Now, no political party in Pakistan has ever shown courage to disown Chapter 3A of Part 7 for being part of the constitution without compliance of Articles 238 and 239.
Please tell us the silent feature of Chapter 3A.
So, Part 3A makes elaborate provisions regarding Federal Shariat Court. Article 203A imparts overriding effect to the provisions of Part 3A over every other every other article of the Constitution, including Articles 8 to 28, which deal with the fundamental rights. So let us see what's the effect. Therefore, theoretically, even if there are any fundamental rights for the minorities to enjoy, they are overridden by virtue of Article 203A. Now, Article 203B contains definitions relevant to Part 3A. Article 203C says that Federal Shariat Court shall have 8 judges. All of them have to be Muslims. Now, the judges are the Chief Justice of the Federal Shariyat Court, 4 judges who are or have been the judges of the High Courts in Pakistan, and 3 are judges who have been ulemas with 15 years experience. Therefore, all the judges have to be Muslims. Article 203 enjoins the Federal Shariat Court that it can act either suo motu or on a reference made by the federal or provincial government or on a petition by a Muslim citizen, not any other citizen, to determine whether any law is repugnant to the Holy Quran or Sunnah. What does this mean? This means, in effect, that any progressive legislation passed by the federal by the parliament of Pakistan or by any legislature of the province to give effect to any international convention will become void for being repugnant to the Holy Quran or Sunnah. If any repugnance is found in law, it has to be cured by the federal parliament in the case of federal law and by the provincial legislature in the case of a provincial law. Article 203E empowers the Federal Shariat Court to regulate its own procedure. It also provides that parties before the Federal Shariat Court can be represented only by Muslim lawyers or alims. So, this is the provision. Either as judges or as lawyers representing the parties, all of them can only be Muslims. Therefore, supposing some person from minority has to argue that, sir, just see the law which is under challenge as being repugnant to the Quran or Sunnah is not so repugnant. It's in accordance. Even then, he cannot appear and make that plea. So, anyone who thinks that minorities have any rights, fundamental or legal, is just being delusional. Thank you.
Thank you, sir. I think that will end the query which arose in the episode number 2, and we will end this episode for now.